State wish to call the case.
Yes, thank you, Your Honor. This is State versus Matthew Mayfield Johnson Jr., 14C42686. Defense counsel Gail Ryder is present with the defendant who is out of custody, Doug Hanson for the state. Your Honor, this is the time and date we had set up for a change of plea in this matter. It is my expectation that the defendant will be entering no contest pleas to counts 1 and 2 of the indictment. And we have a stipulated agreement. UCJ offer worksheets have been provided to counsel and the court. I can go over that at the appropriate time. I will say that this has taken extensive negotiations. I think this is a good resolution to this matter. I think all parties are ready to proceed.
Ms. Ryder.
Thank you, Your Honor. If I may approach, I have for the court a petition to enter pleas of no contest on counts 1 and 2, executed by Mr. Johnson after review with counsel this morning, together with a notice of suspension.
Okay. Mr. Johnson, would you go ahead and stand up, please? Mr. Johnson, how are you this morning? Okay. Mr. Johnson, I have before me a plea petition. Did you go through that with your lawyer?
Yes, ma'am.
Did you understand the things your lawyer has told you?
Yes, ma'am.
Do you understand that if you give up your right to a trial, all that will be left is for me to impose this sentence, which is, in fact, a downward departure?
Yes, ma'am.
Has anyone made threats or promises to get you to do that today?
No.
To the charge of delivery of oxycodone within 1,000 feet of a school as an 8B with a presumptive 35 to 40 months, knowing that there's a downward departure, how do you plead?
No contest.
Okay. And count 2, promoting prostitution as an 8B, presumptive 35 to 40 months with a downward departure, pursuant to agreement, how do you plead?
No contest.
Okay. Go ahead and have a seat, and what the state needs to do is fill in some facts for me.
Thank you, Your Honor. If this had gone to trial, the state would produce evidence that on or about May 16th of 2014, at a location at the Shiloh Inn of 3304 Market Street, Northeast, room number 419, which is within Marion County, the defendant was in a hotel room with his wife, Jessica Johnson. There had been an agreement between Ms. Johnson and an undercover officer to engage in sex for money. The officers had arrested her. The defendant was in a closet, had come out, and indicated that he was there. The officers had talked with him. It was discovered through information provided by Ms. Johnson and the defendant after Miranda rights that he was there assisting her in the promotion of the prostitution. She had indicated to officers that she shared the money and the proceeds of the prostitution with her husband, which is the defendant. Further inquiry on the cell phone of the defendant was found text messages that were consistent with that. Also text messages in regards to the oxycodone, where he was trying to sell 50 pills of the oxy to a friend named Nick for $200. And that was found on the defendant's cell phone. He indicated that the text messages were accurate. We still don't know who Nick is, but that he had it was constructive delivery in that location based on the fact that he still had the cash. The oxy pills were found in the room in his wife's purse. There's a valid prescription for the defendant, but he of course can't sell those, and that's what he was attempting to do. So the totality of circumstances would show that he was actually delivering oxycodone, a constructive delivery, on or about that time. The text message was the day before, as you heard in the motion. I think that would be sufficient for those pleas. In regards to being in 1,000 feet of the school, it was within 1,000 feet of Hoover Elementary School within this county.
All right. Ms. Ryder, I understand that there's been an agreement between the parties. Is there anything else that you'd like to tell me?
At this time, Your Honor, we stipulate that if the state were to put on evidence without any evidence from the defense, that those are the facts that the state would be able to prove. No, Your Honor, this is as Mr. Hanson has said, this resolution is the result of a number of different negotiated possibilities, and we are asking the court to impose the sentence as stipulated by the parties.
Certainly. All right. Mr. Johnson,
Yes.
go ahead and stand up. I've heard a lot about this case through the motions. Is there anything you'd like to tell me?
I don't even know what to say about this. I've been fighting it for 14 months, and I stand here and tell you that, you know, it's not true, but I'm at a position where I feel like I don't have help, so I have to do what's right for my kids. You know, if I didn't have kids, I would see this through trial. But being that I'm a father and I love my kids and my wife, I would like to have an opportunity to show that I'm not the person that they made me out to be, the officer. So I understand Mr. Hanson's job as a district attorney, and also my lawyer Gail Ryder's job as my private counsel. But at the same time, I was never given an actual chance to show evidence, and I further would like to appeal it using my rights. So that's all I have to say.
So she's going to be stumbling, trying to fix this, right? But Gail Ryder pulled me in the hallway and told me that I have appeal rights, and I push to get those rights, and along the way, they've been cheating. Douglas Hanson left the Marion County DA's office in order to manipulate and cheat my appeal. I'm going to put on the paperwork too, so this is going to be one of them good streams. So if you watching, please share this, get it to the right people, get it to the appellate courts, because I can assure you that no judge is really seeing this
You signed this document,
at
and in
11:30.
this document, you were stipulating to a plea. Okay. What I hear you saying is that you want this deal.
You don't hear me
It's called a
saying
Halford
that.
plea.
I don't. No,
Basically,
they coercing me.
you want the deal.
No.
You're pleading no contest because you
No,
want the deal.
that's a
The
lie.
state's willing to come off
It's a lie.
of a presumptive prison sentence so that you can get a chance to show that you're a different man than these charges would show.
Mm.
And you're entering this plea knowing what the state's evidence would be.
Because I can't put on none of
And
my
you're
evidence.
saying, I'm entering a no contest plea because if I presented no evidence,
Right? Why would I not put on
the state
evidence?
would be able to make their case.
No, the state is bullshitting.
And that what I hear you saying is that you're entering that plea in part
In part,
because you believe that it's in your best
I don't have a
interest
choice. Why
to
wouldn't
enter
it
a
be?
plea.
Why wouldn't
Is
it
that
be?
right?
Yes, ma'am.
Okay.
Why wouldn't it be? If I
And
can't
you're
put on
pleading
no evidence,
no contest in order to get the deal.
and that
Yes, ma'am.
no,
Okay.
they
Now-
coerce me, man.
At the bottom of this thing that you signed, this plea petition, it says, I understand that by entering my plea, I am giving up all right of appeal.
That's a lie.
Okay. So, unless the sentence imposed exceeds the maximum allowed by law, which it doesn't,
Cause y'all put me on probation. That's why.
basically, you're giving up.
What
the
about the
right
cruel and unusual part of it?
So you're taking that deal and you're agreeing with the state.
No,
That's it.
no, I'm not. True.
I'm going to show I'm a different man. I'm going to look after my children. I'm going to take this downward departure
She's talking
so
for
I
me.
don't go to
A
prison.
fact-finding judge.
Which
they
potentially
trialed me.
could happen if I went to trial.
Yeah, I bet.
So I'm going to plead no contest. And they're going to come out of the presumptive
There,
sentence
no,
and ask the court by stipulation
no.
to come out of a presumptive prison
It was all a
that
setup.
you might face if you went to
It
trial.
was all a setup.
You might be found not guilty,
I was not guilty.
but you might end up facing a
I was
presumptive
not
innocence.
guilty. Period.
So, here's
Y'all
the question.
cheated me.
You're signing a document as part
Watch
of
what
your
I tell
plea
Tripp.
that you're giving up
Watch what I tell this
all
lady.
rights of appeal.
Watch
You're
what I
taking
tell
the
her.
deal, and that's that.
And that's not what Miss Ryder just explained
To me,
in the hallway.
right.
I literally asked her if I could appeal within 30 days, and she told me yes.
And if I may, Your Honor,
Sure.
I think that the statement in the plea
Hello?
petition is a bit too literal. Under current law, a person is entitled to file a claim for appeal or a notice of appeal if they can state a colorable claim for the appeal.
Yeah,
Now, I know
actually,
under
I
when
don't-
you enter a
my
plea,
wife
whether it's
called
guilty or
in
no
for work and
contest,
she didn't
those
know
rights can be
that.
very limited. But if the public defender's office, after consultation with Mr. Johnson, can find a colorable claim for appeal, then a notice of appeal could be filed, notwithstanding what the plea petition says. That's my understanding of current law. So while he has limited appeal rights, he still does have some appeal rights. I think that the plea petition is a little overbroad in its language,
Yeah, you can call that.
because I think the plea petition is designed to make sure that people understand things are going to be very limited. That's my reading of the plea petition.
Your Honor, I know that there are, of course, post-conviction rights that the defendant has that are separate from appeal rights. That's something that potentially is still there. I don't know. I don't do PCR. But if there are claims that the defendant has against his prior counsel, he may be able to file appeals with PCR on that. I don't know.
That's why you left it
But here I do
Marion
understand
County
that there's very
DA's
limited
office.
rights in regards to appealing this conviction.
Oh, don't take a
sentence.
deep breath,
It's an unlawful
Hanson.
sentence imposed by the court on the defendant. The defendant absolutely has a right to appeal that.
Yeah,
And we're not objecting to
you
that.
can eject. You can, because you know what y'all did was wrong. Y'all know
So,
it.
you've heard counsel explain to you that there are narrow rights of appeal.
Uh-huh.
And by this,
Uh-huh, Trev. Get yourself out of this lie.
this says that I'm giving up all rights of appeal to a higher court unless I can show that the sentence is unconstitutional.
Which it is, because you can't use
or
my
it
wife
exceeds the
to
maximum
charge me.
amount.
You cannot do that. Y'all know y'all
Further
can't.
understand that a notice of appeal must be filed
Now she got a
30
whole
days.
different tone.
and that the notice of appeal must be sent to the district attorney, the trial court administrator, and the trial court transcript coordinator. I understand that if I apply
Now
for
she
an
just
attorney, and I
mad.
am indigent, an attorney may be appointed for me.
Gail Ryder
represent me on
fucked them,
appeal.
and now they forced her to retire because she fucked them over.
Yes, ma'am.
Yeah, I agree to that. If I can appeal my
With-
case. But they hung me on my PCR. Watch how I do you. Watch how I
I'll
do.
go back and accept your pleas to delivery of oxycodone within 1,000 feet and promoting prostitution with, as I outlined before. I'll again accept the statement of facts that the state outlined before. I'll consider this a stipulated agreement.
Mm-mm.
As I said before,
This is a hate
I'll
crime.
enter the guilty pleas for the record. As I said before,
I'm sorry, just make sure it's clear there's no contest, please.
oh, I'm sorry. I'll enter the no contest pleas as stated on the record before. Right.
Yeah. Take a
Anything
deep
else,
breath.
Mr. Johnson, that you'd
Yeah.
like to tell me?
You in trouble, Trip.
Okay, all right.
That's the thing.
Pursuant to the stipulated agreement
Gail Ryder got y'all in trouble right there.
on the delivery of oxycodone within 1,000 feet of a school, I'll find that you're an 8B, as in boy, 35 to 40 months presumptive sentence. The that the parties stipulate to both a dispositional and downward departure to 36 months, and that all general conditions apply. The forfeit all items seized, comply with all drug conditions that are imposed as part of Marion County Court's sentences. Blood or buccal sample, license suspension for 6 months.
For nothing.
Fines and fees of $200, attorney's fees of $1,035, and the condition that you comply with the conditions of count 2. In count 2, I'll find that you're in 8B again, 35 to 40 months, that there's a stipulated, and the court agrees to dispositionally and downwardly depart to 36 months of supervised probation. All the general conditions apply. All the special conditions of
Sex offender packet.
She didn't
the
even
sex
know.
offender packet
Just
comply
doing
with
Douglas
count
Hanson
1.
a favor.
Defendant may have contact with Jessica Johnson, his children, and all minor children within his extended family, which shall be on the judgment. A blood or buccal sample, sex offender registration, fines and fees $200, felony $1,200, and the $1,200 shall be paid from the money seized. In
That was mine. That's my money.
189.
That didn't come from prostitution activity, Doug.
Anything further from the state?
No, I just wanted to let the court know and counsel know and the defendant know that I did have a chance to speak with Ms. Johnson yesterday at a pre-scheduled meeting we had with
I
an
bet.
advocate by phone, and we talked a lot about this plea, and she understands what we were going to do today. She was notified yesterday when
After
our
you
officer
dog
that
my
it would
wife
be a
out,
plea.
you want to lie.
So she had noticed at least if she wanted to be present, but that she knew that I was offering a probation. She still was. I can let the courts know that she still was not happy.
Who
that
would
the defendant
be?
Was having to plead to the charges.
Who
but
would be? What
happy
wife
that he was
would
not
be
going to
happy
prison.
that
And
a
I do think
prosecutor
this is a
used
good
her?
resolution, Your Honor. There's been extensive negotiations, motions,
That's a lie.
and I do hope that the defendant can comply with the probation, meet the criteria. We did have a lengthy discussion about the sex offender treatment, etc. He has to have an evaluation according to the
Took
the
him,
conditions.
passed
But if
him.
that
Y'all
comes back
didn't
that
put
he
him on
doesn't need any
record.
sex offender treatment, then he doesn't have to do sex offender treatment. Promoting prostitution by law is a registrable offense, so he does have to register. I provided that to Ms. Ryder. He'll have to sign that today. But it's not the typical.
It's not the
sex abuse
typical.
type conviction.
Come on,
That
man.
the state has concerns of him having any kind of a sexual abuse to children or anything of that nature. So we understand that hopefully this will be a limited type of probation where he can actually comply and complete it and be done. Thank you.
That's a lie.
Do you have
All of this is a
judgments
setup.
for me?
The UCJ's
Oh,
trying.
no, you
She
suggest-
didn't even have a judgment.
Yeah.
She didn't even have a
Go
judgment
ahead
to
and have
give
a
me.
seat, Mr. Johnson, and I have to take care of some paperwork.
This
Yeah.
is the registration notice. We need to sign right here.
They filled it out for me and all that, had it already ready for me. Didn't let me fill shit out.
I'm sorry.
Next matter is Jessica Johnson, 14C43220.
Yeah. We got to play all of
Ms.
this.
Johnson is present, Your Honor. On her behalf, will acknowledge receipt of a one-count information. Will waive further reading and advice of rights. Ms. Johnson's true name and date of birth are correctly set forth therein. Your Honor, she would like to take advantage of the EDP offer, which in this matter is that it be treated as a misdemeanor. $100 fine, $20 towards court costs, book and print. She and I have been through the request for attorney. The petition comes from legal. We're prepared
They
to
just
receive
set me up. How you charging my wife if I promoted her? If I forced her into this? How are you behind the scenes charging her?
You're Jessica Johnson.
We had the same
I
judge.
understand what your attorney just said is you want to plead guilty today to one count of prostitution.
Sean.
He
has provided me a couple documents indicating your decisions. The first is a request for an attorney and acknowledgement of limited investigation.
A
Do you have an
limited
opportunity to read and sign this
investigation.
document?
So how the hell you get
Do you have an opportunity to
anything on
discuss
me,
it with your
Doug?
attorney? You understand that with this document, you're requesting appointment of an attorney and have agreed to pay $20 for that service. You're also acknowledging that because you want to take an early offer today, your attorney does not have the opportunity to review the discovery in depth, investigate the charge, or prepare defenses on your behalf.
Because they was busy
You're gonna waive
illegally
that right?
prosecuting me. That's
I
why
will accept that as a knowing acknowledgement.
I played this backwards for a reason, because they prosecuted my wife first,
Okay, the
and then
petition
they
and
used
plea.
the
Did
information
you
to
have an opportunity
prosecute
read
me.
and sign this document? Have you had an opportunity to discuss it with your attorney and what it means to plead guilty?
Yes.
And have you discussed with your attorney all the rights that you're giving up as listed in this document? You understand that one of those rights is your right to a jury trial, where the state would be required to present the evidence against you to a jury, and a jury
Which
would
I
decide
asked
whether or
for.
not you were guilty.
Did never get
You
it.
waive that right? Anyone promised you anything or threatened you with anything not contained in this document to get you to sign it? Do you have any questions for me or your attorney before I take your plea? Alright. And as to count one, prostitution, how do you plead guilty or not guilty? This document says you're guilty because on May 16, 2014, in Marion County, you agreed to engage in sexual conduct in return for a fee. Is that true? All right, I'll accept that as a knowing and voluntary plea. I see the recommendation is a $100 fine, $20 in court costs, and booked and printed.
And
Will
no
you stipulate?
probation, no
Okay, Ms.
nothing.
Johnson, anything you want to say? Well, let me, this is a dangerous business that you're in. A lot of ladies get killed doing this, and other ways to mess up your life. So if you need help getting out of this life or doing something else, we have resources for you.
No, you don't. Not for her, you don't.
I am actually getting the proper help that life I actually stay in Gresham, and I just enrolled in major in nursing.
Okay, this is all something you can overcome, but it is a seriously dangerous way, and many women who get engaged in this work are maimed or killed doing it. So
Is
I
that
hope you'll do something
right?
different. Okay, good luck to you.
Good luck to you too. So, you now what I'm gonna do? I need some room here. Now we're gonna get into this paperwork part of it. I have to go here, and I want to put this down here. I like it down here. I like it down here. We're gonna just use that box right here. Remind you, I went through Susan Tripp, EDP offer. What is the EDP offer? My wife didn't know what they was doing to her. That's why they try to make it to where I couldn't be on my wife. I couldn't have contact with my wife. They made it to where I couldn't have contact with my wife, right? But the courts didn't do it. Just the Marion County Jail did. Ryan Dunbar with the Marion County Jail. I'm telling you, this man cheated me on my appeal, and I spent a couple of days putting all the evidence together about how I can show how he cheated. And this is the thing, they using judges that's in their back pockets. They doing such a corrupted job down in Salem. And then we hear Deborah Kafori trying to get somebody to resign. Girl, you should resign. Facts. You should resign. So what I did was I called Susan Tripp's office and I spoke to her bailiff, right?
Only because of my hello.
Yeah,
Hold on. Never mind. Let's rewind this. I want to give y'all paperwork. I want to give y'all the paperwork. Sorry about that. Sorry, something had happened there. I'm at work. I'm at work. Y'all see a glitch on my computer because I turned my camera off for a hot second, right? I'm gonna pay Susan Tripp bailiff, right? They said that I didn't have trial, but I know for a fact I had trial. I watched too much criminal law, order, all that court stuff, right? So I know, I get a sense of how the inside of a courtroom is ran when you put on exhibits and you filing motions and all that. You taking a person through trial, whether you call it pre-trial motion hearings or not. That stuff, it should be reserved when a person appeal, right? They royally screwed me. When I tell you up shit creek it is. They royally screwed me over. So my whole position was to reach out. I knew that what Gail Ryder told me in the hallway. She said, even though that you take this plea bargain, you can appeal your case. You can go after Kerry Wiley. She knew I was upset. The thing is, they say preliminary hearing don't matter in this case. They say preliminary hearing don't matter, right? Let me explain to you a preliminary hearing. Why it's important to have a preliminary hearing. It's always important to know your rights. It's always important to know what you. And my grandma always told me, if you ain't highlighted anything, you haven't really read it. So I know where to go. If a grand jury finds probable cause, the state issue an indictment against the defendant, and it must stand trial for the charges. It must stand trial for the charges. That's what it says. Now, why does a preliminary hearing occur? Now, listen to when does a preliminary hearing occur. If a defendant is arrested and held in custody, a preliminary hearing must occur within a certain number of days, or the defendant must be released from custody. Is this a reason why I'm forced out of the Marion County Jail? See, the Marion County sheriffs got to do something about me. They have to talk to me, and I'm pretty sure that the Marion County sheriffs don't even know the depth of what Douglas Hanson did, how he just used their organization to cover up his hate crime, right? But the facts is this. I was forced out of jail. It says the United States Constitution and the state constitution, as well as criminal rule of procedure for state courts, provide that a defendant can be held for only a limited time on the basis of an arrest and a criminal complaint. They keep on telling me, your claim about having no preliminary hearing have no merit, and I'm gonna bring this back up because I did go through court where I was appealing it, and at that time I went through the direct appeal, which they denied. Then I was able to go through what's called post-conviction relief. Post-conviction relief was supposed to allow me to put on evidence, but they never let me do that. Coben Patterson tried to make me feel and believe that he was helping me. He didn't help me because he knew. I took his advice. He told me to get on the stand, and I shouldn't have did that. I admit, because even though I'm telling the truth as far as getting on that stand, they always find some way to discredit you, and they take away everything else, right? So my job today is to go over Coben Patterson's information and to show that that man was really trying to help me, and he was screwed. He was screwed over. He was screwed, right? So in order for the courts constitute holding a felony defendant in custody. The courts must conduct a preliminary hearing within the amount of time prescribed by state law, 72 hours here in the state of Oregon, right? And issue a formal charging instrument, sometimes referred to as a criminal information. If a preliminary hearing is not conducted within that time prescribed, the defendant must be released, not charged at the release. You have to release me, drop the charges, give me back my money, give me back my memories and my phone, give me back everything, man. You try to destroy me, man. He tried so hard, Doug. What does it take, man? What? Where is the help? Where is all these organizations at? Where is these pastors at? Where is the help? Why? That's all I say to myself sometimes when I read through this stuff and I see the amount of hate that I had to go through and the will that I had reading. Like, I'm not even an attorney. I don't study law, none of that. All I've been doing is trying so hard to show the world what these people is doing. Is Douglas Hanson that strong of a person where they just don't care about the facts? They just saying he admitted to it. But what about the fact that y'all put leverage on me with my own family, my wife and my kids? I didn't have a typical support base. I was getting up every single day. Every time they told me to show up to court, I was there. Every time I was thinking and I was praying to God like they gonna give me a chance. They didn't do that. They took everything away from me. They took away my medical. They misdiagnosed me. They questioned me under duress. I showed everything I put. This man Douglas Hanson blocked my reports. He blocked my medical. He did everything. He hated me so hard. And he didn't even know me. He did not know me. I sit here every day and I pray to God, like, God, find it in somebody's heart. Find it in somebody's heart to help me. Look at the facts. Why would a man spend 6 years, six years, reading, writing, putting everything in order, reaching out to pastors who saying they gonna help me? You know, I know it ain't their fault, but damn, where's the help? And then look what it say. If a defendant has been released on bail or on his own recognizance, which I was not released on my own recognizance because I did 22 days because they lied to this judge and said, I think he has a parole hold. Did you show those charges when you looked this man's file up? I don't know. They was just lying every which way. Every which way. And every time they lie, I began to pray more and more and more and more. I lock myself in closets and small confined areas wherever I can study at, because I knew deep down inside my promise to God, my promise. Y'all don't understand. For 22 days, they fed me a metformin pill that I shouldn't even been taking. And I was taking it thinking I was a diabetic. But all along, I was not no diabetic. 22 hard days of just saying, no, I'm not going to eat their food, none of that. I went to that med cart, sick. I was struggling. I was losing weight. It was a time where my auntie looked at me and she said, "What's wrong with you, Matthew?" And I said, "Ain't nothing wrong with me, auntie." She said, "It look like you dying." And that's what made me switch my doctors up. It made me leave one doctor to find this doctor named Andrew Ross Harbinson. He began to do all these different tests on me, but at the same time, I'm going through this illegal conviction down in Marion County, and I don't have no support. I can't go to my mom. I can't go to my dad. They saying I lost my mind. And that's why I say the same people that be talking about you be the same people be trying to come and ask you to look some information up for them. Right? If the defendant has been released on bail on his own recognizance, right, the courts can conduct a preliminary hearing at a later time. However, the preliminary hearing must occur within a reasonable time because it's something that's called due process. That's been violated. Y'all keep saying there's no merit. You used the Attorney General to cover for you, Douglas Hanson. You had her and Arias Johnson call me December 21st, December 21st of 2014. You had these people tell me there's no merit. And if you put the Attorney General under oath and ask her if she called me and made a phone call to me, she gonna have to tell the truth. She gonna have to tell the truth. She gonna have to tell the truth. Listen to the pink line, the last line. An unreasonable delay violates the defendant federal constitutional 6th Amendment right. This is why I'm fighting, because I knew my rights. I knew what a preliminary hearing was. I knew what it was, guys. It violates my 6th Amendment right. I got the wrong page up. Wrong page. One thing I can say is my grandma didn't raise no fool. Y'all sit up here and say y'all want to change the way y'all prosecuting cases and charging innocent people, and y'all trying to say victim this, victim that, when the victim don't even play a role. The victim don't even have a voice. The victim don't even get to ask the defendant for what's called the victim impact statement letter. None of that happened in this case. This is, like Paul Lively said, this is the most bizarre situation that I ever seen in my life. And I'm not going to sit back and allow Douglas Hanson to believe and think that he could get away with such a heinous crime. It violates the 6th Amendment right to a speedy trial. If the defendant arrested or charged in a criminal complaint and the prosecutor's office or the court does not schedule a preliminary hearing until months or a year later, the case can be dismissed because of the delay. Y'all still have not ever gave me what I'm fighting for, a preliminary hearing. Dismiss my case and give me everything y'all took back from me. Y'all suspend my license. Y'all took $1,290 of civil lawsuit money, which y'all called Willie Merkel. Y'all got him bagging y'all up. Y'all might have made him an offer, but the paperwork he can't deny because I got it, right? The judge must review the circumstances of the delay and determine whether the delay was unreasonable, therefore violates the defendant's constitutional rights to a speedy trial. I asked for a fast and speedy trial. I waited years to go to trial. Y'all put so much pressure on me that y'all called my wife a day ahead of me going to court. Gave me until 5 o'clock to accept your offer or else. And then I don't know one defendant, not one defendant that will go to trial without having no evidence. What attorney would want their client to go to trial without no evidence? And Gail Ryder, why wouldn't you allow me to put on evidence? Why wouldn't you look at my evidence? Oh, this is going to get deep. It's going to get real deep. This is going to be one of them things that they can't hide from. See, I knew I had trial, and I'm going to prove that. But what I'm saying is we got to read the preliminary hearing. A preliminary hearing is somewhat like a mini trial. The prosecution can call witnesses to testify, present physical evidence or documents and records, evidence to show the defendant likely committed the crime. A preliminary hearing a preliminary hearing usually is not as exhaustive as a criminal trial. And the prosecution likely will not present all the evidence against the defendant, just enough to establish probable cause. The rules regarding what kind of evidence can be presented may be more relaxed than a trial. For instance, hearsay may be permitted. This means that the police officer can testify about the witness, or what witnesses told him during the interviews, and the prosecutors will not be required to have those witnesses testify at hearing. How courts conduct preliminary hearings and what occurs in each hearing views with each state laws and its state's constitution. Rights to counsel at a preliminary hearing didn't get. And we gonna get into that once I get into the post-conviction relief, because that's where I'm gonna expose Douglas Hanson for doing his hateful things to me. A defendant is entitled to have an attorney represent him at a preliminary hearing. If the defendant requests an attorney, the courts cannot. If the defendant requests an attorney, the courts cannot conduct a hearing without assuring that the defendant has a private counsel or appointing an attorney such as a public defender. And that's what he did. He tried to go get this illegal indictment on me with this hearsay cop, Roger Smith, to get this. That's why it's only listed Roger Smith and Eric Hernandez on the indictment, because he using hearsay. You're going to get, man, people. Defendant has a private counsel appointed, such as a public defender, to represent the defendant. The defense attorney can invite the defendant of the right to make arguments to the court about whether the evidence is significant to support a formal charge against the defendant and present evidence on defendant's behalf. Should the defendant present evidence at a preliminary hearing, and should the defendant testify? Whether to present evidence and whether the defendant should testify to a preliminary hearing are questions that the defendant and his attorney must answer in each individual case. In such cases, it may be best for the defendant to simply let the prosecution present its evidence and say very little. In other cases, however, there may be compelling evidence that clear that the defendant shows clearly that the defendant did not commit crimes or was incapable of committing the crimes, perhaps because he was out of the country or in another state when the crime was committed, and the defendant has solid evidence to establish an alibi. In some cases, the defense attorney and the defendant may agree to the defendant should testify at a preliminary hearing. For instance, in this case may involve the issue of self-defense, and the defendant may be a much more credible witness than the victim. This kind of decision is very difficult to make, and a defendant should never choose to testify at a preliminary hearing without counseling with an attorney and exploring the merits thoroughly. Can the defendant waive a preliminary hearing? Let's get to this next page. Criminally, defendants usually have the option to waive a preliminary hearing, but it happens very rarely. And no defendant should do this without the advice of an attorney. If you waive away a preliminary hearing, you allow the prosecution to proceed on criminal charges against you without having to present its evidence. Most likely, a competent defense attorney will recommend waiving the preliminary hearing only if evidence against the defendant has substantial or overwhelming, and waiving the preliminary hearing would benefit the defendant in a significant way. For example, if the case is a high-profile matter involving a great deal of publicity, an attorney might recommend waiving preliminary hearing in order to limit the release of information and evidence to the public. If you are arrested and receive notice that you will be charged with a felony, contact the attorney immediately. An knowledgeable attorney can protect your rights and keep you informed through the preliminary hearing process. In addition, in some cases, it is possible to negotiate a plea with the prosecutor before a preliminary hearing, and attorney can investigate this possibility and advise you as to whether it is a good option for you. And Douglas Hanson just basically cheated me. Now he said that he never trailed me, right? Listen to this.
Okay, it's been assigned to Judge Tripp, so I'm going to have you talk to her clerk, okay? Hold on.
Laura Baker, Susan Tripp's clerk. You gonna see me fighting for my appeal rights.
Good morning, Judge Tripp's office.
I don't know why I was transferred to you guys, but my name is Matthew Johnson, and I was trying to get some information on this indictment that I got.
Okay, well, Matthew, we had the trial with us.
What?
That's why I said, why would they transfer me to y'all when I need some information about this fake indictment I'm under?
Okay, probably because if anybody knows anything about the case, it would be us. So I can tell you about that indictment. What's the case number?
14C42686.
14C42686.
Yes.
Okay. Let me get to the indictment.
I take it back.
All right, I have the indictment. What's your question?
I'm wondering why the clerk never signed this, the deputy clerk for one never signed this, and when I called there several months ago, I had spoke to a jury coordinator with my power of attorney, and they told me this indictment was fake, and I got another issue as far as they listed my wife as a witness in my case, or claimed that she was a victim, and I'm wondering why she never made it to a grand jury to get on the indictment. This is this is wrong because if it took 2 police
Okay,
officers.
let's do one question at a time. Do you want to know my answers, or you just want to keep talking?
Excuse me?
Yeah.
I said, do you want to? Because you're asking questions, but you keep talking. Let me do one question at a
Okay,
time.
my main concern about this indictment is where the victim or the witness at.
That hurts.
Okay, yeah, I just showed that an R. Smith and an E. Hernandez came and testified against the grand jury.
And that's the reason why I got concerns is because if it only took 2 police officers to go to a grand jury to get an indictment, how many other people would be arrested and charged?
Yeah, I don't know that because I don't work in grand jury. That would be a district attorney's office.
Right, exactly. And they've been giving me the runaround, and I knew they was going. They not supposed to send me to you guys because I'm under appeal, and I'm not letting this go. These police got in Judge Tripp's courtroom, and they lie. And not only that, they telling me that there's a supposed victim because I got to register as a sex offender, but I'm not seeing how this indictment even got passed. How it got even accepted with no victim or witness.
You know, like I said, that's the district attorney's office, and we just get the cases from the district attorney's office, and we just process and mediate them.
So, what do I do about this situation? Because it's a lot wrong with this indictment, and I know for a fact that this is not a real indictment because I spoke to the jury coordinator a couple months ago saying that it was never filed with the deputy clerk's office.
Well, it's on appeal, right? Do you have an appellate attorney?
I haven't got in contact with them yet, so I don't know where that's going.
Okay, and which jury coordinator did you speak with?
It
Like
was
I'm
some
supposed to
random man.
I'm supposed to give them the information so they can get the person in
I was
trouble.
talking to him, and I was recording this whole thing, so I know it's true.
Yeah.
You know, because I recorded it.
Yep.
So you have a recorded conversation
Sure
with the jury
do.
coordinator?
Yes,
Sure
I do, and it's not against the law to do it because I was at
I
home.
didn't say that. I hope you know I didn't say that. I
Yeah.
simply asked you a question.
So when they say don't record them, they
That's all I
lying.
needed to know. And I know you had a question in the beginning why it wasn't signed by a clerk.
Yes.
And those are only signed by a clerk when they're copies.
What? None of
I
mine
had
is signed by a
copy,
clerk.
and I still don't have a signature by a clerk.
Is there a barcode on it?
What? Yes, it is.
Right
Okay, then
here.
it's certified. Once we print it off the internet, off our website, it certifies it by itself.
No.
That's illegal.
No. Hell no.
That's illegal.
That's fucking.
We want to
That's
see a
illegal.
signature just like
That's
that
illegal.
grand jury foreman person who I think Douglas Hanson forged, and it's Douglas Hanson name on it. This man is bad business.
I've been trying to tell them.
Those are the things you probably want to bring up with your appellate attorney because now that we have e-court and everything's electronic, we don't have papers anymore, then a lot of things go through that. If you had the real certified copy, it would have a court stamp on there. But now that we have e-court,
Where is it?
things are changing.
Where is it?
So that's something really that you probably
My case
need to
started
bring up with
before
your
y'all had the
appellate
privilege
Right,
to
but
use
you know,
e-court.
my biggest concern is I found out that I was also under a control number, and nobody want to tell me what the control is. You know.
The control number is your fingerprint card number that attaches you to the crime.
Oh, okay. Well, thank you, ma'am. And I will be still digging on this fake indictment that was filed months later after my asked for a fast and speedy trial. Like I said, this man Douglas Hanson is bad business, and he's
I'm
getting a
talking to
lot of
Susan
people
Tripp
involved in this
Bailey.
corruption, and I'm starting to see where it's going now. You know, he claimed that my wife was the victim / witness, but why didn't she make it to a grand jury to tell her story? Why was there only 2 cops?
Right, and those are really good questions, and that's why your case is on appeal. And
No, it
that's
ain't.
why
They lying to me.
They listen to testimony about that.
Okay, well, thank you, ma'am. I'm sorry if I was being rude or anything like that. It's just I've been fighting this hate crime on me for several months, and now that he let me and my wife be back together, we put our information, our case summaries together, our plan of actions, and I'm telling you right now, this man is a bad district attorney. I don't care if he sit on a high committee chair or all that. I've been investigating this man, and I've been reading up on his behavior and his background, and it's totally wrong, you know. So thank you, and
You're welcome. I hope you all the best.
oh no, I will be back in that courtroom on the docket, and I know they've been lying to this judge, Miss Tripp, because when I was in her, when I finally met her for the first time, she told me she knew nothing about me, but she assigned me 3 different attorneys. So, you know, they played me like I was stupid, but, you know, like she told me, you got to keep on your Joker face, and she never knew if I had my Joker face on.
Right. Well, like I said, I want you to really, those are your appellate attorney. Once you find out who that is, make sure you bring all that information to their attention.
And
So you see me reaching. That was the first time that I reached out to Susan Tripp, right? But it get deeper than this, because Douglas Hanson said in my court audio transcripts when I very first started this live, I played my court audio transcripts of me being charged, and he said that he don't do PCR. He's not familiar with PCR, this, that, and the other. I can prove to you that he know about post-conviction relief. He know about direct appeal. He knew that I was on to him. He knew everything. This indictment is fake. It's fake. They could have charged me with murder, and I could have went to prison for life. If the charging instrument said murder in the first degree and it 2 cops, boom, I would have been gone. And like I told her, if it took 2 cops to go and get an indictment, how many of us all would be charged? His evidence don't even fit the charges, right? So we digging in on the appellate and the appeal, how go upstairs and play. That's why I'm not buying y'all no more balloons. Give me that now. Let me see that. Look at this.
Hell no.
You want it? My kids always find a way to get me. Looking at. Let's see.
hi, is this the Court of Appeals?
Yes, it is.
Hi, my name is Matthew Johnson, and I was currently a client assigned to an appellate attorney out in Salem, Oregon, by the name of Ron Chananuyich. I'm calling because I have been gaining a lot of information, which got me having some concerns about my brief actually being past due, 287 days. And I was trying to figure out if there's an actual judge assigned to my case.
But I ain't gonna play that one because that's not what I'm looking for.
Only because of my... Hello?
Your situation, that's really something that you need to discuss.
Hold on, I gotta find it.
Or press pound to use the staff directory. For contract, wait while I transfer your call. Good afternoon, Office of Public Defense Services.
Hi, my name is Matthew Johnson, and I have recently put in a pro se to ask for.
I'm gonna save that one.
Read you my case number. You see.
I'm gonna save that one. I'm gonna save that one. That's. I got too many videos I'm looking for.
Fox Public Defense Services, Roger, and you guys.
That's him.
I was told to give you guys a call and see if you guys could possibly help me figure out what court appeals my appeal actually is in.
Okay, do you have any numbers or anything?
Yeah, I got A for Apple 159992.
And that was State of Oregon versus Matthew Mayfield Johnson
Yes.
Jr.
Yes.
Okay, it seems like it did come through here and it's been decided and dismissed.
They what? Excuse me?
I said it says case status is decided and dismissed.
Dismissed as far as what? Go.
It was just affirmed without an opinion.
Oh, I haven't got no information from no attorney regarding that. So, when did that happen?
On the 25th of this month.
On the 25th of this month.
And 6 days ago.
Okay, does it read a judgment in it or anything of that nature?
It just says affirmed without opinion. I'll give you to Frank because he does the end and wraps up the cases.
Okay, thank you.
This is gonna be. This is very, very important.
Here, let me give you this number.
Okay.
You already have it. You gave it to me.
Yeah.
So when you give Frank, just give him that A number.
Okay.
This gonna be very, very important.
I'm going to transfer to Frank right now.
Thank you.
Frank is gonna tell me what to tell Ron Chananuvich. And I'm gonna do exactly what Frank telling me. He's basically giving me legal advice without saying it.
Hey Frank, I was just transferred over to you to try to figure out some information regarding my appeal that I was under.
Okay, do you have that case number handy?
A as in Apple 159992.
Okay, let me get in there. And that's State versus Matthew Mayfield Johnson Jr.?
Yes, it is, sir.
Okay.
Like I was asked, he just brung it to my attention, something that I didn't even know because my lawyer that was on this case has not been in communication with me for a very long time, and I found out that my case went to somewhere to where a judge was supposed to make a ruling on it. So I was trying to figure out what if there was a judgment involved in this.
Now, the judgment is not yet issued. There is what's called a dispositional decision. The court made their decision, and it goes before a panel of 3 judges, not just a single judge. And in your case, since it was a Balfour, it could have been a panel of 2. But it was affirmed without opinion on the 25th of January. And what that means is the affirm means that the court agreed with Marion County's decision. If they think there's something kind of a little unusual about how the law is applied or something that's unique about the situation they want to bring to the attention of other judges and attorneys, they'll write a formal opinion explaining why and how they applied the law.
Yeah, where is that?
Unusual about it, they will simply do it without opinion, and that's extremely common. They do this an awful lot. So it was affirmed without opinion on the 25th.
Maybe we should change that.
That sets 2 time frames. You and your attorney have until the 8th of February
Listen.
to petition the Court of Appeals to reconsider their decision. Petition for reconsideration, asking the Court of Appeals to think about it again. There's a second timeline that's running at the same time. We have until the 1st of March actions of the Court of Appeals to see if there were errors made.
Oh.
So those are still open. Once that happens, once those times go by, if nothing is filed, about a week and a half after that, the judgment will issue, and that's what actually closes the appeal and returns it to, I think it's Marion County in this case.
Yeah.
Down.
And
Dogging.
my last question with this is, I'm having a difficult time even talking to the attorney, and he know by the judgment that he got from Marion County that my claim was that there was no underage victim that was prosecuted, let alone a victim listed in my judgment. So that brung up a error issue to me that, and he put in a Balfour brief. And I understand what the Balfour brief is. And like I told him, at least Balfour had victims in his case that they said that he sexually molested on and did these allegations towards, you know. That none of that happened in my judgment. And I tried very hard to stop him from placing a Balfour brief, and he proceeded without even looking through my pro se motion. So, you know, I'm not having luck with any of the attorneys there because it's a conflict of interest on Marion County and a district attorney prosecuting an illegal case. You know.
It's not a conflict of interest, but obviously you're not happy with it. But like I said, there are things that are open to you at this point. You're represented by the Office of Public Defense Services. Even if you're not getting direct contact back from me, you can always send them a notice saying that I'm requesting that you file a petition for review in this case as soon as possible. That way you're on the record as having voiced your opinion to your attorney of what you want to have happen.
Of course I did that.
Okay. Thank you, sir. Yeah, thank you a lot.
So you see what our homie told us, that two different things was running on his clock. And I know Douglas Hanson is watching me with his fake profile. Just know that I know, and everything that I've done up until this point has been recorded, and now I'm ready to just release it because I know y'all keep cheating my appeal, and enough is enough. So I reached out to the attorney Ron Chananewich. I reached out to him.
Office of Public Defense Services, Ron Chananewich.
Hey, Ron Chananewich, I'm calling about my next step to what I need you to do as far as my appeal process go.
Yeah, so you got my letter telling you that the Court of Appeals has affirmed your opinion without opinion?
Yeah, but there's other things that I can do. I want you to file a motion asking for a reconsideration to the Court of Appeals, and not only the Court of Appeals, I need you to also file a motion of reconsideration to the Supreme Court of Appeals.
Okay. What I can do is petition the Supreme Court under the Balfour procedure, where I will attach your letter as a Balfour.
I'm running a live stream right now.
Uh-huh.
I don't think I have a basis to file a motion for reconsideration with the Court of Appeals, but I will double check that for you and let you know.
You can check it all you want, but I know that I have until a certain amount of time to do that. You know, I don't know who's been. And I want to exercise that deadline. And I also want to exercise you filing it on the Supreme Court. You know, I'm tired of being played. You know, there's a lot of errors in this decision that's made in this judgment because there's no listed victim for one. And that should have been an error that been brought up, you know.
I have to make a colorable claim to them about why the Court of Appeals would have to consider their...
Man, I'm not looking for a job.
I just told you the colorable claim, didn't I?
No, I did, but that's not something I...
Let me ask you this. Do you have the judgment from Marion County signed by Susan Tripp, yes or no?
What?
I
Go on
Okay, well, can
Facebook
you
and
open
you'll be
up
able
that
to see me.
judgment? Can you open up that judgment? Look towards the back of the page where it says
Go on your
list the
Facebook
victim.
page, look for my page, and click on the live stream. That's what I'm doing. Yeah. Check it out.
That's really your only avenue for me filing a motion for reconsideration.
Right.
And,
I will file a petition for with the Supreme Court to review your case, though. I will attach the letter that you sent to me.
and what letter is that, sir? What letter is that?
It's the December letter that you sent to the Court of Appeals.
Gotta make sure.
Okay, yeah, I got a copy of that. I think I know what you're talking about.
Well, you sent it to the Court of Appeals, so that's the letter that I sent.
Yeah, that reconsideration. Yeah, I've been asking, and I also sent the conflict of interest sheet along attached to. You still got that attached to it?
See how I switched it up on them?
Oh, okay.
There's multiple pages, but it's all one document.
Yeah.
Stop doing
Okay.
that.
Or not, you can file
Right now.
your own motion for reconsideration with the Court of Appeals, making your own arguments. Okay?
Okay. Thank you.
Then what the hell was you my attorney for?
Bye bye.
What was he my attorney for if he was willing to let me pro se? Right? What was he my so if he was telling me to do this pro se and I've done it, why did they deny my pro se? We'll get into that on my next video right here.
Or press pound to use the staff directory. For contract, wait while I transfer your call.
Stop.
Good afternoon, Office of Public Defense Services.
Hi, my name is Matthew Johnson, and I have recently put in pro se to ask for a reassignment in my attorney, Ron Channing Nudich. And I was wondering what was the ruling on the judgment?
Did you need to speak with Mr. Chananudich?
Yes, I do.
Okay, just a moment, please.
I'm going on a break, but y'all could still see the paperwork.
Office of Public Defense Services, Ron Channing Nudich.
This is Matthew, Ron. I have put in a motion to transfer lawyers with you because you put in that brief on me, and I was wondering what was the actual ruling on my motion.
I haven't heard anything from the court. The court asked for my position. I submitted. I think my secretary should have provided you a copy with what I submitted to the court, but the court hasn't said anything yet.
Which was illegal for you to do. You filed the motion on me without mine being ruled on.
Mr. Johnson, I didn't file any motion. The court asked me to respond to your request for an attorney, a different attorney, and I responded with the response that I gave to the court. That's what I did.
Remember, I told you don't file that Bradford brief on me, and you did anyway.
Yeah, that's. I wrote in the letter saying that the deadline to file the Balfour brief was this date, and if I did not hear back from you, I was going to file the Balfour brief.
Now
I did not hear back from you, so I filed the Balfour brief.
You want me to tell you why? Because I was illegally arrested by my new probation officer and placed in jail. So there was no way for me to even respond, even if I wanted to.
Mr. Johnson, I told you the date that the brief was due. If I did not file the brief on that date, then the court would have dismissed your case because they would not receive anything from you or from me. You understand? It's the court's deadline.
Right. But what I'm saying is that I didn't want you to file that brief under the colorable claims that I explained to you previously. And you seem to don't get it.
I understand that, and I gave you an opportunity to file the Balfour B brief. And if you would like, after the situation with the attorney change is resolved, you may be asked the court for an extension to file your own brief as well.
Absolutely, because it's cool and unusual for me to be registering as a sex offender without no victim. You clearly seen that on the indictment that you got in your little.
Mr. Johnson, I explained to you the reason why I couldn't raise that on appeal. I explained that to you on numerous occasions. Is there anything else that you need to tell me right now?
I don't understand this, but as you know, Douglas Hanson, the one that gave me this offer, he retained himself a lawyer.
Okay.
Oh, okay.
Solely because he violated my constitutional rights. And I ain't had no help at the appellate level.
Mr. Johnson, I can't raise that on appeal as well. I can't raise any prosecutorial misconduct like that. That's a civil matter that you could raise with the bar if you would like. And as I mentioned before, if you do not feel like either my representation or the trial attorney's representations were effective, you could raise a post-conviction relief claim against both of us.
That's what I'm saying. Why do I have to wait until post-conviction relief to file complaints against y'all when y'all supposed to be doing y'all job?
You can also file bar complaints against us as well, but that's not going to get the relief that you're seeking. You have to go through the direct appeal process before you go through the post-conviction relief process, because the post-conviction relief process assumes that you've already exhausted everything that you could have under the direct appeal process.
And that's absolutely not the truth. And I know what Belfort brief means, and I'm really disappointed in this.
Mr. Johnson, I explained to you what a Balfour brief means. A Balfour brief just means that I did not find a colorable claim, and therefore I'm submitting a brief because you don't want to dismiss your appeal. And the Court of Appeals understands that.
But that's conflicting with what Irene Taylor said to me. That's why I'm so confused and crossed up, because she found colorable claims and then she passed it on to you, and now you telling me there ain't none. So which one of you guys is telling me the truth?
So when we file a notice of appeal, we go by a lot of what the trial attorney tells us and what the client tells us. It's not until when we actually look at the record that we can actually file a brief. Filing the notice of appeal, the bar to file a notice of appeal for a colorable claim is fairly low. If we receive some information that this may be a colorable claim without investigating it, we can file the notice of appeal. But after we look at the record, we find out that that colorable claim is no longer colorable. We can't raise that issue on appeal.
That's a lie.
It's like when you're filing something with the court, you're telling them, hey, I think this may be a colorable claim. But after you do research and you investigate it, then you realize, oh, you know what, actually it isn't. We can't present that argument to the court. Because when we present the argument to the court, we have to explicitly tell the court why it's a colorable claim.
Right. And my whole thing is
no longer.
And my whole thing is, when Douglas Hanson said in them transcripts that this is not the typical type of registration where the state has any concerns with me being around children of that nature, then what type of sex offender am I then? You know what I'm saying? That's
Mr. Johnson, I explained to you already. I can't raise that on appeal because
it's in the transcript. It's in the transcript that you got, and you're not raising it.
But you stipulated to the sentence.
I didn't stipulate to anything. They coerced me and psychologically, mentally forced me into it. They used my family and my wife and my kids against me to get me to sign this deal. And I keep telling you that.
Then you could raise that on post-conviction relief. I can't raise that on appeal. I'm sorry, Mr. Johnson.
Solely because the district attorney stipulated on me. He stipulated. What did I stipulate to? What in the
sentence that you stipulated to the sentence that you received?
No, but
plea petition, Mr. Johnson. Can I finish, please? The plea petition listed the offenses that you were going to plead guilty to, or I'm sorry, no contest to. It also had the sentence that you were going to agree to, and it said stipulated sentence, and then it has your signature and your date, and you signed that.
That's the thing. When I went and signed that They never had that judgment in there. As you know, that's an e-court judgment. That's an e-file document. That was a document that was known. Let me tell you, you my attorney, and if you my attorney, you need to hear it from me because I experienced it. And I'm tired of you keep on trying to cut me off and make it seem like you know what's going on because you study law. You know what I'm saying? But this is my life that I'm fighting for. You know what I'm saying? When they gave me that, all they gave me was a petition to enter plea. That's what I signed. I never signed no judgment.
That's not what the Court of Appeals is going to see. The Court of Appeals is going to see the judgment. The Court of Appeals is going to see.
So there's paperwork missing then. That's what I'm saying. That's a colorable claim, ain't it?
I can't raise that on appeal. You can raise that on post-conviction relief, but I can't raise that on appeal.
Give me a break. Y'all just don't want it to go to the higher courts. What can you raise on appeal then? What can you raise?
If it's a guilty plea, if it's a stipulated guilty plea, there's really limited things that I can raise.
And what is your limit?
Excuse me?
What is the limit in things that you can do? Because to me, you haven't done anything but file a Balfour brief.
That's your opinion, and I invite you to...
No, it's the paperwork. It's the paperwork.
I invite you to file post-conviction relief against me if you do not believe that my representation of you was effective.
It's not. You know it's not. You know it's not.
Mr. Johnson, is there anything else that I can help you with right now? Because right now we're just going back and forth.
No, I want you to explain to me why you asked me to give you time or give time. You gave me time to put in a subsection B, right? You gave me that time. I then made the decision to say, you know what? No, you want me to explain to you, so I'm gonna take the time to explain to you because after this I'm not gonna never talk to you again. So I want you to know for facts. You know what I'm saying? You asked me, you gave me time to put in this brief, right or wrong, correct?
No, the court gave you the time.
Okay, the courts gave me this time. Well, what I'm asking for the courts is before that time is that I'm indigent for one. I don't have the correct attorney representing me and letting me state the colorable claims, right? So I then put in a pro se asking for a reassignment of an attorney. You then went and said, I don't care. Even though I put that on you and the Attorney General way before that brief was due, you went in and e-filed the Balfour brief.
Mr. Johnson, you didn't serve me with that request for a new attorney. The court didn't send an order saying I was no longer your attorney. So what that means was...
You just don't even understand.
Mr. Johnson, can you please let me finish? The court said that your brief was still due on that date, and either a Balfour brief was going to be filed, or if nothing was filed, the court would have dismissed your case.
Mm-hmm.
That's what was going to happen.
It's getting dismissed anyway solely because you placed the Balfour brief on me, and at least in the Balfour case, the State versus Balfour case, he has several named victims in his case. What victim do I got in mind that you can't raise a colorable claim on?
That doesn't matter.
To make me a sex offender.
That matters. You could have raised that in the Balfour A brief.
Yeah. Okay.
If you would like, you can still move the court to file a pro se supplemental brief.
Right. I need a different attorney that's really gonna look at my case.
I understand that's how you feel, and that motion is before the court right now. When the court responds to that motion that you submitted, I'll let you know.
Read you my case number. You saying that you telling me that you don't see no information about me being under appeal in your office?
Right, but it could be that, I'm just not, because you don't have the file number, you're giving me the case number, but we have like a specific file number. It's usually 1, 2, 3, 4, 5 digits long. It usually starts with 6. And since you don't have that, I'm just looking you up by your last name, and I'm not seeing you there. So I just was
the lady just
the name of the attorney that represents
His name is Ron Chananudich.
work in our office. So, give me a second.
What?
So you should be here. So let me see. Maybe I'm not spelling Johnson right. How do you spell your last name?
Johnsson.
How can you not?
Yeah.
Hey.
Yeah, I have a Matthew Craig, a Matthew Allen. That's not you.
My name is Matthew Mayfield Johnson Jr. I went under appeal in July.
Okay. Let me see if I can. Do you have, well, you know what? Let me see if I can find you.
Do I have what?
Do you have do you have the brief with you?
Well, I put in a brief that got denied, but you know, it's not. It was from Marion County, and it did. Oh, it gives me this number right here. A as in Apple 159992 number.
Okay, so that's A159992.
Yes.
Okay, let me try that one.
Not right now.
There you are. Okay.
Why
For
am
some
I
reason,
heading out?
that was not showing up. Okay. I see. Okay, got it. So I see your file. It looks like the state's brief is due on January 3rd. So it looks like the appeal is still ongoing, which means the appeal has not concluded. So you cannot file for post-conviction relief until you have a judgment from the court. And you won't get a judgment from the court until the case concludes or you go ahead and dismiss the case. So once you get a judgment, then your attorney will send you the information about the post-conviction relief appeal process.
You know what's so funny is, I don't mean to cut you off right there, is that over a year now since I've been dealing with this man Ron Chananudich, he has already sent me my post-conviction relief paperwork and all that you just got done explaining to me. He had already sent that to me, and he also told me to raise the claim about how he was ineffective on my appeal and that I could raise it in my post-conviction relief, and he sent it to me. So I'm not understanding what's this January date all about. He filed the Balfour brief when?
Okay, I will let you know. 1 second. So, looks like it was filed in June 7th.
And do you have record of me ever filing a pro se motion asking for a reassignment in attorney for him?
Yes, I see that here in May.
And then it went through electronical filing system, and it got immediately denied without a judge seeing it. So I'm wondering what's going on with that situation.
I don't exactly know, but it looks like, let's see.
I'm pretty sure having no judge seen that motion that I put in, because I cited federal laws and why it was a breach of ethical violations with Ron Chananudich, and he's not raising the colorable claim, which I I had talked to Irene Taylor about is the fact that on the initial indictment that he got with the court audio transcript, that there was no label vulnerable victim, and that's enough for me to, and the reason why I'm saying this is because I'm a sex offender for it, and there's nobody that I have to stay away from, or but I'm going through a lot of things in my life where my life is altered because they trying to say that there's a vulnerable underage victim somewhere.
Got it. Okay. So, I guess I have several things. So, one, it sounds like you're not interested in speaking to your attorney.
Absolutely not. Never. I got some videos about him and his ethical violations that will blow your mind, man. Though it's like he got paid to put in a Balfour brief when he know at least Balfour, in the Balfour situation, there were victims, there were listed victims, there were people that he had to stay away from. In my case, on that indictment, like I kept on telling him, even within the transcripts that he got written out, for him to read, the transcripts from the initial date that I took my plea offer states that this is not the typical type of case where the state has any concerns with me being around any children. But yeah, I'm going through court right now because I've been around kids and my wife. It's like the whole thing is contradicting, and he won't file the correct paperwork to get it in front of a judge, so that way a judge can see that there's no victim on this case, and it's cruel and unusual and unconstitutional that I'm a sex offender without producing the habeas corpus,
Sure. Okay. Well, it sounds like you have some concerns about him, and so one thing you could do is you could write a letter, and address it to
the attorney general. I already did all that. I that's what I'm saying.
Sorry, to who?
I felt this letter on the attorney general, the DA's office, him, and I still haven't got. All I got was an order immediately.
Okay, I'm sorry. Let me just interrupt you because it's not what I was gonna say.
Okay.
I was gonna say send a letter to our chief defender, the person who runs this office.
And what's his name? And how do I go about doing that? Because another thing that I want people to realize is that Douglas Christopher Hanson, which was the deputy DA who prosecuted my case, he left the Marion County office, and he's been tampering with my mail. He's been invading my privacy. He's been really cheating, and I've learned about electronical filing system because of the dirty work during the DA, and the information that Ron Channing-Newdich got. He can easily see that when you stamp the actual paperwork to make it original, certified true copy of the original, Douglas Hanson changed that font so that you guys couldn't see when the actual dates, and all the dates are the same, 12/8/2014. Like, he changed font on paperwork and all that, and I've been crying and complaining to Ron Channing-Newdich, and I've been telling him, in order for you to file this Balfour brief, you have to produce this vulnerable victim, because I do know who that man Balfour was, and he was a very bad sex offender type dude. And when the courts of appeal hear that there's a Balfour brief, it automatically get denied. So if he, like he was telling me, that the Balfour brief is gonna automatically get denied, then why is he restricting me all the way till January 3rd to, what I'm saying? In order for, I'm ready to go to post-conviction relief right now.
Right. Okay. Well, if you want to do that, one thing you could do is you could go ahead and go talk to your attorney. I can't help you with that, and you would have to maybe ask him to see if he could dismiss your case, and you'd have to, but then you would be dismissing your case if you wanted to try to accelerate.
Right, and that's what I don't want to do. I do not want to dismiss the case and cheat myself out of getting. I do not. I want to repeat this.
I understand that.
Okay.
Okay, so then what I would do then is, then unfortunately there's no other way than to wait for the judgment to come out, so I can give you information about that. Like I said,
Okay.
you know, you're not going to be getting a judgment until, you know, sometime in the next year, because it looks like it could happen before that, but it's unlikely, but it could happen, because basically the appeal process is not complete. So, you know, the state needs to file a response to the brief that was filed. Once that happens, then the court, you know, schedules the case to be submitted, and then the court makes a decision and then issues a judgment. So
and this is the.
Have to let. I'm sorry.
I'm like so confused because everybody's telling me the court. I want to go in front of a judge because this e-filing and electronic filing system that everybody is using is so corrupted that ain't no real judge seeing the truth. It's the computer that's prosecuting me pretty much.
Yeah, no, I understand that you're frustrated, and I wish there was something more I could do to help with that, but I can't.
So how do I get in front of a judge?
I don't know that you can, because that's not how the system works at the appeal level.
So I'm just being prosecuted by a computer. And that some I ain't trying to sound funny or nothing, but Ron Chananudich is acting like he God, and he's putting in faulty paperwork, making the computer believe it, and then when the computer believes that, then I don't have no chance. All my remedies is exhausted because of the computer, you know, and ain't no real person, a human being. If I committed a crime on a human being, why can't the human being see the truth about the crime that I committed, supposedly, you know? Because anybody can say anything about, oh, yeah, he got a victim, here's the name, and the computer believes that. That's not fair to me, and it's taking away my equal protection. It violates my civil rights, my constitutional rights. I'm solely in trouble right now if where my probation officers is telling me that I'm spending a tremendous amount of time trying to appeal my case. So I'm like, I'm going to in and out of custody for this, and there's no victim. There's no victim. So why he, as an actual lawyer, won't take this in front of a real humanized judge and say, you know what, this case shouldn't have never happened because there's no victim. In order to put the Balfour brief on me, you have to produce that habeas corpus. And Ron Chananudich is finding it very hard and difficult to do because of the information he received from the court audio transcripts says that there's no victim involved. Even on the indictment itself, there's no listed a victim that went to a grand jury for these charges to even be prosecuted on me. So to give all the control and power to just Ron Chananudich and whatever somebody has influenced him to put into that computer to make the computer accept the judgment is unfair to me. I'm just being completely honest, Mel.
Sure.
And Ron Chananudich would not give me the time of the day. All he's been doing is sending me copies of the same document judgment. I'm asking him this question: where's the actual judgment that I took on the day that I went and took in this plea offer, which was July 9th, 2015? There should have been a judgment and a UCGA offer together. But all of a sudden, there's just this document type of judgment and I told Ron Chananudich that's not a real judgment because he took my case summary, and he turned Douglas Hanson took my case summary and turned it into a judgment, and he starts sending it to everybody. You know, I didn't agree to that.
Right. Well, it honestly sounds like you may have a case for post-conviction relief, so, you just kind of have to, unfortunately, wait for the process.
Okay. That sounds reasonable since I'm going up against a computer brain and not a human being.
Yeah. No, I get that you're really frustrated, and I understand it's a very frustrating time.
At the appeal level, when my case get out and it's settled, and I'm gonna have a say on what's going to happen, solely because Ron Channing-Nudich and his conflict of interest upon me is the fact that this what is it called? E-court has to be taken away from the appellate level. Y'all have to go physically and present this case to a judge. That's all I'm saying. Because you presenting it to a computer. So whatever you say, if you told the computer that the sky was red, the computer gonna believe you because you entered it in. So I guess that's all I got. Long as I know that it's under appeal and my probation officers is lying in their reports because they telling me that I'm not even under appeal.
Oh, okay.
And that's the reason for this whole call is because right now I'm going to Marion County Court, even though my case was transferred to Multnomah, and they said I supposedly committed all these crimes in Multnomah. They keep sending me back to Marion County, icing me out. I do 14 days. They force me out of jail. You know what I'm saying? They keep forcing me out on the same original charges. But they told me when I took the case that the case was closed out. So my other question was, if the case got closed out when I took the plea bargain and unsatisfied, mean they were unsatisfied with what happened because they knew I wanted to appeal it, so they was unsatisfied with it and they closed it out, but somehow it got reopened. And I'm going through nothing but drama with it. And they telling me that my appeal ain't real and none of that. I mean, just playing with my mind, and it's not right, it's not fair, because hadn't this been in front of a real judge and not waiting for a computer to approve it or deny it, I would have got help and relief from it.
Right.
Well, thank you so much, ma'am. I don't want to keep on, sounding like I'm beating on a dead egg right now. So I do get the fact that you don't have really much control over it. But there's something that Ron Channing-Nudich, I haven't spoke to that man in a long time. He never was my attorney. He never gave me any kind of relief. He never gave me any chance to go over anything with him. None of that. Pretty much it was just, I'm doing what I'm doing and I don't care what you say.
Right. Yeah. I'm sorry that it's been so frustrating.
Yeah, and he denied my motion so fast that it blew my mind. Like he said he's seen it, but I had called the back there before, and they told me that my motion hadn't even been ruled on, but he had already filed the Balfour brief. So the Balfour brief trumped my motion anyway, because he filed it even though that there was a motion still out there, not ruled on.
Right.
And this is the kind of attorney-client relationship that I have with this man at the appellate level. This is not the judicial level. You're dealing with the federals now. You're a federal lawyer to me, and you're treating me like I'm a scumbag, like I don't know the law, like I don't know what's going on, none of that. And it's not fair. And I've been trying to get him off of my case and nobody won't listen to it. So can't there be like a conflict of interest there to where I can transfer my case to somebody else?
That's up to the court to grant that, and I can't help you with that. It looks like the court has denied that. And I'm not your attorney, so I don't know anything more beyond that.
No, they didn't deny a conflict of interest. They denied the fact that I put in a pro se motion on a reassignment of attorney.
Oh, okay, I'm sorry. So you're saying, I guess it would still be a motion for a new attorney. You're just saying you didn't make that argument before.
No, I wanna raise the fact that there's a conflict of interest.
Oh, okay, well, yes, but then your attorney would have to do that. So you'd have to talk to Ron Chanadue.
And he don't want to talk to me because he know I know the law. He know I know the truth.
Right, well, you can send him, a letter with your request, or you can call him, and make that request.
Okay, thank you.
Okay, good luck.
Bye-bye.
Okay, bye-bye.
I'm all cried out with nothing to say. Only because of my hello.
Yeah, it's going in and out, so I can't hear you that well right now, Mr. Johnson.
Could you hear me now?
Yeah, I can hear you now.
Okay, I'm calling you because of my situation. Remember how I last talked?
Your situation, that's really something that you...
I don't know what has.
Hi, is this the Court of Appeals?
Yes, it is.
Hi, my name is Matthew Johnson, and I was currently a client assigned to an appellate attorney out in Salem, Oregon, by the name of Ron Chanadue. I'm calling because I have been gaining a lot of information, which got me having some concerns about my brief actually being past due, 287 days. And I was trying to figure out if there's an actual judge assigned to my case, because, and the reason why I'm asking this question is because the appellate attorney, Ron Chanadue, had claimed conflict of interest on me, and he wants me to now write my own legal brief.
Okay, do you have a case number?
14C.
Oh, sorry, do you have a case number that starts with an A?
What do you mean, A?
That would be your appellate case number.
Oh yeah,
case number?
yes. A as in apple. 159992.
Okay, Matthew Johnson?
Yes.
Okay, let me look and see. Okay, so what it looks like is that your attorney filed a motion for extension of time on the 25th of April, asking for more time to submit the brief, and he put the reason is that he sent you material to prepare a Section B brief, which basically just means that he's going to submit an opening brief, but if they submit a Balfour brief, that means that they don't think that there's any reason to have the appeal, so they give you the opportunity to write a brief yourself that they could submit with their brief. So the new due date for the brief would be June 6th.
And this is my thing. I don't know how he gotten to this point. For a very long time, Ron Chanadue had strung me along. I don't know how he put in the first motion. No, I don't have no information on why my brief is actually 287 days past the.
So you actually don't need to pay attention to that part. Basically, what happens is that when the appeal is filed and after the transcript is being settled, we give the public defender's office 210 days to file an opening brief. So that's where that 287 is coming from, because they had the original 210 days, and then he had requested another extension for time. So that's where the 287 comes from. It just comes from when the transcript was being settled.
And I'm not understanding why he's not acting as my appellate attorney
I had been through a very difficult time with at least 7 public defenders out there in Marion County, and each and every one of them know that there was never a victim on my case to prosecute me. And I'm very aware of the Balfour brief, and I'm telling him that I don't want him to put in that Balfour brief solely because I'm not no sex offender. And after like reading on who this man is and what this man done, it's illegal for Ron Chananutich to put in that brief. And not only that, he know that I suffer from a lot of mental issues where I need help understanding the criminal part of this, and he's putting it solely all off on me, knowing that I'm not able to do it.
Okay. So are you wanting to not have him as your attorney, or wanting a different public defender?
Absolutely. I've even contacted the ACLUs about him, and they've been streaming me alone down there at the public defender's office where he's actually located. I've asked him to reassign me a new attorney solely because of how he been treating me. He even admitted to me that I can claim these claims in post-conviction relief. But my thing is, I got colorable claims in that you can raise issues on solely because there's no victim in this case, you know.
Okay, so what you, I mean, if you're not wanting him as your attorney, you would have to file something like the court knows that you want him, taken off for whatever reason. And then from there, the court might be able to have the public defender's office reassign it to a different public defender.
This is the thing that they
would only be able to happen if you filed something.
And where do I file this information? This is information that Ron Chananutich and company is not sharing with me, and they know that I don't know how to do this or get this accomplished. So I'm guessing, and I've recently been hit by a vehicle where I'm under heavy medication, so I don't have enough time to study and have this brief in by the 6th. And he gonna put in that Balfour brief, and that's the sex offender thing. That's a brief that solely talk about how this man manipulated and committed sex offense towards people, and that's not who I am, you know.
Okay, so I could give you our address. Do you have something to write it down with?
Oh no, you can go ahead and say it. I got pen and paper.
Okay, it's 1163
State
Street,
Mm-hmm.
Salem, Oregon 97301.
Okay.
And you can just send it, to the Court of Appeals, to that address, and just request, that a different public defender be put on your case. You would have to serve a copy on the Attorney General's office. Do you have their address?
No, I don't have none of that information.
Okay. I can give that to you also.
Okay.
It's 1162 Court Street Northeast, Salem, Oregon 97301.
Okay.
So when you send something to our office, you also have to send it to that address.
Okay.
And on your document, you have to say that you sent a copy to that address as well.
Okay, so I guess my ending question, because what led me to call you guys is the fact that I'm aware of how everything is under the e-filing system, and I was trying to explain to Ron Chananutich, person that he had set in by the name of David, and then they transferred me to some other boss man. So they was just playing this triangle because I know that they've been manipulating this e-court system, and like I said, I don't want no dealings with them because earlier in life, Jessica Kempfee had claimed a conflict of interest on me on all public defenders of Marion County, so it's like they've been covering up a hateful crime, and even that district attorney that prosecuted me has now quietly resigned. So now I'm being cheated out of my appeal too.
Okay, yeah. So that would be the process that you would have to go about. getting a different attorney to file something with our court and then send it also to the Attorney General's office.
And what do I do about like having, since my brief is done at a certain time? What do I do about that if I'm in conflict with the appellate attorney that's not willing to work with me?
So if you get that filed before June 6th, then that would suspend the brief, due date until they dealt with figuring out what to do with your attorney.
And this can be written on a piece of paper, or does it have to be written on a certain format for me to write and put on Ron Chananudich and the appellate?
Have you received documents from your attorney of how he files them?
Well, yeah, I kind of get it. Is that the format? Because I don't want to just write a letter.
Yeah, so across the top, how it says in the Court of Appeals of the State of Oregon,
Uh-huh.
and then it has the state versus your name and the case number. That's information that you would want to put on there.
Okay, and I can write it out, right?
Yeah,
Just
yeah,
long as it looks somewhat like that format.
right.
Okay, I'll have this in ASAP.
Okay,
Thank you so much for your time, Mel.
you're welcome.
Bye-bye. Again, Ron Chananudich has been called up. I've asked his bosses and him for a reassignment. What I did know is that I had to file the notice myself in order to get a new public defender. I've been fighting a hate crime since May 16, 2014. Follow me as I uncover the truth on this hate crime done by Douglas Hanson, who had help by several different people. I'm disgusted, I'm drained, but I gotta keep going for my kids. That was just me on the phone with the appellate division about Ron Chananudich misconduct. And furthermore, I will make an effort on writing him up through the Oregon State Bar.
Your situation, that's really something that you need to discuss with him. As I mentioned before earlier in our telephone call.
Can I stop you right there for just 1 second? My problem became once it got to Ron Chananudich, I know about electronic filing system and court protective orders and such things like that. I did go through trial with Susan M. Tripp, who was my trial judge. There have been witnesses that took the stand. There have been a lot of things, but what I found out was Douglas Christopher Hanson, the actual prosecutor of the case, had put in a protective order to protect certain things from getting to the appellate. Not only that, he had convinced my attorney to make me stipulate without me knowing what stipulation meant. So if I stipulated to it, what was the reason to go up under appeal, So I never wanted to stipulate. I wanted to see it out through trial.
Have you tried? I'm sure you guys have talked about this, but have you at least heard of the word PCR, post-conviction relief?
Yes, I'm aware of post-conviction relief, but I'm also aware of the fact that I gotta exhaust all my remedies before I can produce the habeas corpus, right? So I know that I need to wait and get a review from the Supreme Court, you know.
Correct. However, with your post-conviction relief, the purpose of that, so just going back to the basics of how an appeal works.
Okay.
Appeal is about whether the judge made a mistake. Post-conviction is about whether any of your attorneys have made mistakes. And so, if Ron didn't think that the judge made any mistakes, that was the conclusion he came to. There's nothing really that you can do about that other than write your own brief if you want to, and sometimes people do that. But if you really disagree with Ron or something that your trial attorney did, the way that you challenge your attorney is through PCR. And you can't challenge your attorneys through an appeal. You can only challenge what the judge did.
And I can't challenge him through PCR right now because I want to make sure that I reserve the right to my habeas corpus. So they.
It won't affect that to the extent that if one of your attorneys failed to
Ineffective at counsel.
exactly.
Yeah, I know. Trust me. I know a lot about this stuff. And the most difficult thing that I'm having is the fact that when Ron Channing-Nudich got that indictment and he seen that there was no listed victim or witness on there besides the Salem police, that should have been more than enough colorable claim. Because how are you making me register as a sex offender and do sex offender treatment when you didn't even list the victim in the indictment or the actual judgment?
Well, I don't know whether that's right or wrong.
That's what I'm saying. It's the paperwork that he sent, and if he's saying that he wants to raise a colorable claim, or if it's cruel and unusual punishment, I understand that it's not I'm not at the maximum sentence allowed. It's not over the maximum sentence allowed. But where they failing to look at the facts in the colorable claims is the fact that it's unconstitutional for this to be going on. It violates my amendment rights to my 4th, 5th, 6th, 8th, and 14th, and also my 2nd Amendment. And that's what I'm trying to get him to understand. If I went through motion hearings through trial, why is none of my motion hearing proceedings in the appellate part? You know?
Well, that's it. Obviously I don't know the details of your case, and I'm not going to go into details of it with you. Those are very good questions. They're questions that you can raise in PCR. I don't know if you submitted your Balfour Part B.
No, let me stop you right there one more time. During the time that Ron Channing-Nudich wanted me to write this Balfour brief, I made a decision to put in a pro se to ask for a reassignment, only because I was hit by a car and I was under heavy medication, so I wasn't given the applicant time to research the case to even figure out how to present a brief in the first place. And that's what I was trying to explain to Mr. Channing-Nudich is, hey, man, I'm really sick. I even had him have my doctor get in contact with him and write a letter. So when he gave me that time, I asked for a reassignment, knowing that the probation officers is using intimidation towards me, placing me in and out of jail. How am I supposed to write a brief when I'm in and out of jail? So then my next question was, and it's been on my mind for a long time, is I know that the state has to respond to the brief by January 3rd. So that means I still have action in putting in what's called a supplemental brief. And that's what I want to do since they haven't responded to the Balfour brief, because at least in the Balfour brief, there's some victims. In my case, there's no victim. You know, so how can you compare it to the Balfour brief? And that's where I'm like, because I do a lot of reading, but the thing is, the probation side of things for this case is they stopping me from exercising the right to even research. So I'm really limited to what I can do as far as write an actual brief. So my next question to you is, am I still eligible to sit here and write the supplemental brief to add to his Balfour brief? Because it's completely wrong.
I think
I still eligible? But am I still eligible right now? Because that's been my fight. If I'm able to still put in my own part of the brief, then I won't have no problems with Ron Shannon Nudich. The problem that I got with him is he's not telling me my rights and the timing. I'm not an appellate attorney. I don't know
Yeah,
when.
no, and I am an appellate attorney, and I don't know the answer to your question off the top of your head. What I do know is there's a right way to do it, and then there's you're taking a big risk way to do it.
Right, that's what I'm saying.
The right way to do it that preserves all your rights, that is every bit as effective as something titled a supplemental brief, is to write a Balfour Part B brief. They mean the same thing. The name on the cover is irrelevant. You will be able to convey every argument and every position and every concern that you have had in your Balfour B, and so it's really probably the better procedure for you to follow is to file that,
Because
and that
I don't want.
know that you're going to get your argument heard by the Court of Appeal.
Right, and I don't want to be in a situation where they try to get me with procedural default. You know, I know about all this stuff, you know, and that's the thing. So I guess my question to you, am I still eligible to put in a Balfour B brief still?
Are you late?
That's the thing. I don't know what the timing, because I'm not like Susan Tripp, the trial judge, said. I'm not schooled in that area to know when the courts give time. Ron Shannon Nudich, all he said is he put in a Balfour brief, and then he gave me a certain amount of time to put in the Section B of the Balfour brief. But then here you got my probation officers taking me back and forth to jail, and I'm hit by a vehicle under heavy medication. So how am I supposed to do this?
Hold on, I'm just reading your letters between you and Ron, just so that I know when he wanted you to have the Balfour Part B back.
I was in jail, so there was no way I can get it to him. That's what I've been trying to explain.
Matthew.
I see.
That's exactly
Bring
why
your
I
brother's
asked
phone
for
down.
a reassignment, because he wasn't listening to the fact that I was being set up by the probation officer. So in order for me to protect myself, I wanted to file something to where that way I could get some type of help while I'm sitting in jail. Because you know when you in jail, you restricted. You don't get all the, resources.
Yeah. There's two things. One, I will go check and see if I can find any support.
Stop.
First, I would say you should try.
Not him.
You
Tristan.
should try to maybe file both. You can write the same. I don't know if you have a computer, but if you do, you could write the same exact arguments, and on one of them put a cover page that says supplemental brief, and on another one, Balfour Part B, and submit both of them, and ask the court to accept them, and that way you have the best chance. I think probably the most likely outcome is going to be that they're not going to accept something from you at this late date, but it does not mean you shouldn't try. I think you should always try. You should always ask. There's no harm in asking.
Because the procedural default means that, I know what procedural default means, and that's saying that the state is saying that they didn't get to preserve their rights to protect my constitutional rights. So I know that. So I want to be able to give the state a chance to see that this is a frivolous case. You know what I'm saying?
Well, let me go and ask around and see if anyone's ever heard of filing a supplemental brief when the
You want me to
defendant...
tell you exactly where I got this information from?
No, I know that. I just want to know if anyone has ever seen it happen before.
Because I called the Supreme Court, the Oregon Supreme Court, and they the ones that told me which brief to file, because Ron Shannon Nudich won't tell me. That's one of the things that I'm having a problem with him on is I don't know the timing of the brief, when it's supposed to be in, and what type of briefs that I could file to preserve my rights from that procedural default.
So your Balfour Section B was due on June 6th.
Yes,
So quite a long time ago.
and I've been in and out of custody.
Yeah. And I think it could be that, I mean, one thing that you should know is that, I mean, a lot of our clients are in custody, in prison or in jail, and they have to follow the same rules as those people who are not in custody in terms of getting their briefs done. They do have access to the law library to some degree.
Yeah.
And so they do have to do it too that way. So it's not an excuse. I just want you to know that it is a fact of life that when a client wants to do part of their own work, if they're in custody, they have to figure out how to do it from the prison, and the prison has to make it available. They can't deprive them of it.
But that's the thing, I'm being deprived, and I'm out. You know, the thing is, they use it, and it's nothing to do with you. I want to stress that, or Ron Chattanooga, you know, it's been confusing because I'm fighting the fact that I'm on probation. If I really wanted this plea bargain so much and it was only 36 months of probation, why would I go under appeal for it? That doesn't even make sense. I've been fighting this for a very long time since I took the plea, you know, and they got restrictions on me like don't use the internet, don't do this, don't do that, and it's stopping me from researching on my case so I can get the relief that I need, you know.
Is it truly one of your restrictions that you can't use the internet?
Absolutely. That's why they keep on putting me in jail and cock blocking me. So now they went back and said, well, he can use the internet only to contact the attorneys and my doctor, but I can't research. I can't do nothing, you know. And I'm tired of going to jail for trying to show my innocence. That's all I've been doing. And that's what I've been trying to explain to Ron Chattanooga.
I'm going to put you on hold really quickly while I just go see if anyone has ever seen the court grant a motion for a supplemental brief when the client didn't file a Balfour B. But regardless, even if no one's ever seen it happen before, you should still do it. So that's going to be my ultimate advice to you in the end. Just do it. There's no harm from doing it. So just do it. And if you don't do it, you're going to lose, period. So there's no harm in doing it.
Yeah.
So I'm just going to go ask around and see if anyone's ever seen it happen
And
before.
this time I'm going to make sure that it's notarized so y'all can't refuse it. Because the last brief that I put, the pro se brief that I put in asking for a reassignment, the reason why that one got denied is because it wasn't certified. This is what the Supreme Court's telling me. So I know about it.
Let me go. I'll go ask around. You just hang on right there.
notarized, and I wanted to just he's my appellate attorney, and he was supposed to talk to me so we can go over the case and state the colorable claims. Now, when I seen the information that was sent from Gail Ryder, who was ineffective, he shouldn't have never talked to her, but I know he had to because she was the last attorney on record for me. But she salted me to him. She told him a bunch of bull crap, and he went and took that, and he looked at the fact that I stipulated, which Gail Ryder never explained to me. So it's...
So wait, so Matthew, let's talk about it this way. Every complaint that you have about Ron, you'll get your opportunity to take him to court to fight with him about that. Same with your trial attorney.
Okay.
You got that. That's preserved. That is your right, your constitutional right. That's going to happen. It's not going to happen during the appeal, though.
Okay.
You don't get to complain about your attorney during the appeal, just about what the trial judge did.
Okay.
And so, what you should do is get your document notarized today if you can. I think you can go to a post office or a bank.
I know how to do that. Before I get it notarized, I'm going to have somebody else read over it because I got a dyslexia problem and I want to make sure everything is correctly spelled right and stuff like that. So
yeah, and I mean, this is another thing. My clients end up writing Balfour B's sometimes or supplemental briefs sometimes. The court is not going to punish you for misspellings or misperiods or miscommas. They really won't.
Okay.
So long as they can understand what you're trying to say, basically, you will get the benefit of the meaning of what you're trying to say.
Okay.
So don't feel hesitant. A lot of clients, because either they don't feel confident with, as professional appellate writers, they don't feel confident, they don't want the judge to see their mistakes, but I tell them, don't worry about it.
Okay.
The judges don't care. They're not going to hold it against you. If you make a correct argument and it's misspelled all the way through, they will give you the benefit of your correct argument.
That's all I wanted, man. You see how simple that was? And I do the work myself, but the near fact that I'm being consequenced for trying to research, because being on the internet, you can research your case way faster, than I don't have money to buy books and stuff, I pay bills and stuff. So my only option is to use the internet to research and figure out who Belford was. Belford is a bad man, and that's not who I am. So that's the whole fight in me, is the fact that I don't want to be labeled with that man.
All right.
Okay.
All right. Well, I'm glad that I was able to help you. I know that it's been kind of a frustrating road for you dealing with some of the attorneys here, and so I'm glad I'm able to help you a little bit.
Trust me, it's not y'all. It's the prosecutor that sent y'all the information, because y'all in a whole different resource center than the DA's office. So I know that for a fact.
All right. Well, you can do either one of two things. You can either send your supplemental brief to our office,
Okay.
and I will get it and make sure it gets filed.
Okay.
Or you can do both. You can send it to our office and to the court. It may be, so that might be the safest thing to do, send it to both.
Okay.
But if you send it here, I am covering Ron's desk. He's out of the office right now, and so if you send it here, I will try my best. And then there's no guarantees, right? We're asking the court.
I know.
But I will make sure it gets filed if it gets here. Let me see what day it says that the date. Okay, yeah. So I think if you can get it here this week, I think we will be able to get it filed.
Okay.
All right. Good working with you.
Thank you.
All right, bye.
Ron Chananudich knew for a fact that I didn't want him to write this Balfour brief. Now you telling me that there's no judgment have been made on this, but like, don't you think that's a bit of a red flag that Ron Channing-Nunich didn't even let them, come up with a argument on the brief that I put in to stop him from doing that?
Did Ron know that you filed the motion?
Yes, I talked to him about it and I warned him that I was going to do this because he had given me until the 6th of this month if I wasn't going to put in some form of writing to him about that. That's why I filed it on the Attorney General's office in his office, and he knew about it, and he chose to still put in the brief without hearing what the Court of Appeal said about my pro se, and that's illegal. That's all I want somebody to understand is that this man put in this brief without them, telling, like you said, you don't see it nowhere in your file where they made a ruling at on the brief that I put in to stop him, right?
Right. I don't show that they ruled on your motion at all, and then he filed the opening.
He manipulated the e-court system by e-filing this brief, and they think that I don't know about it. You know what I'm saying? Why is it that he still went against the courts and not let the courts fully investigate the colorable claims in a pro se that I wrote to stop him from putting in that Balfour brief?
Right. Yeah. I'm not sure what happened there, but what I'm gonna do is, if nothing else, I can forward a copy of your motion to the Public Defender's Office and to the Court of Appeals and say, hey, are we accepting this Balfour brief that was filed? Because it looks to me like there's still a motion requesting a different appellate attorney that you guys have not ruled on.
Right. And that's all I want is a fair chance, ma'am. That's all I'm asking for, and that's all I've been asking him for. And he strung me along for almost a year helping Douglas Hanson out. He's been a part of this corrupted game, and he think that he gonna get away with this. Like I told him, when I put in this Balfour brief, I explained to them, and he didn't even let them rule on it. He went behind their back and filed e-court this ruling without even taking it in front of a judge, and that's illegal.
Okay. Your phone number here, 503-594-9748, that's written on your motion?
Yes.
Okay. I will ask one of them to certainly rule on your motion, one way or the other, and for have somebody call you and let you know what's going on. Because like I said, unfortunately, there's nothing I can do here.
But don't you think it's too late for them to rule on a motion since he put in that brief already? Here it is, the 9th,
No, they still have to rule on a motion that's sitting there.
Wow, he just gonna put in a brief without them ruling. He just dogging me out. He's not a good attorney. That's proven fact right there. He's not working with me, reaching ethical violations, and that's all I wanted to know is, what can I do? I mean, I know y'all the defense that's trying to represent this crap, but at the same time, I'm not giving equal opportunity at all.
Right, I completely understand the frustration if they hadn't even ruled on your motion and then you're surprised by a brief that gets filed. So I'll see what I can find out, Matthew, and I will honestly ask somebody to get back to you, hopefully, today, but possibly tomorrow. I mean, because it's getting late in the day today.
Okay, thank you so much, Mel.
You're welcome. Good luck.
Bye-bye.
Bye.
I was just on the phone with the Attorney General's office about Ron Channing-Nunich illegally e-filing, e-courting a brief on me, which I had asked him not to do. Please follow me as I uncover this corruption. Douglas Hanson, again, have been having several people contact him and help him cover up this hate crime. Case number 14C42686. Today is June 9th, 2016. My name is Matthew Mayfield Johnson Jr. for the record.
thank you guys for watching. Be tuned for the second part of this stream, which I will be streaming Ron Chananewicz connection with the post-conviction relief attorney Coben Patterson. There's so much that I can't stream it all right now, so what I will do is end it, and I will say thank you guys for watching. Have a blessed